Aaron Maduff, just coming out of arguing the case before the Supreme Court on the Pension Reform Act, what is your overall reaction to the arguments you've heard on both sides?
I felt that the state did not have answers to what we put in our briefs. I felt very good about the way the arguments went, and we got the critical points across. The state learned that nothing is absolute, that the Constitution cannot be absolute. That is of great concern to me. The Constitution is not a guideline, and that's what the state is asking for. And particularly when the state is saying, you know, we now have this problem. It's a problem of the state's making. It's what I call the Lizzie Borden defense. Lizzie Borden took an axe, gave her father 40 whacks, and when she thought that she was done, she gave her mother 41. Please have mercy on me, I'm an orphan. That's really what we are talking about here. We didn't fund these things for all these years. In fact, in Skłodowski, we took $21 million out of the pension fund so that we could spend the money elsewhere, and now we have a problem, we can't pay it. That's not an acceptable answer to the situation.
What would you say to the argument that was made by the Solicitor General relative to, as I understood the argument, the pension clause, the diminishment clause in the Illinois Constitution, she was arguing was unconstitutional relative to the federal Constitution because it violated the sovereignty of the state by binding its hands, so to speak.
The state has cited U.S. Trust Company for the proposition that it cannot deprive itself of the police power. That's not what the U.S. Trust case says. It says that the contract clause of the U.S. Constitution is not absolute. It says that the state is not necessarily bound by contracts it makes. But it also points out in that same opinion that we have always held the state to its debt contracts. And that's what we're talking about here. Money is owed to people. So I think under an appropriate reading of that case, the state is wrong.
Let me throw this out relative to a debt contract. The state borrows a lot of money. It issues bonds. When you just brought that up, if for the sake of discussion, the Supreme Court upheld the law and that therefore the state could in effect renege on the contracts that it made with the state workers, would that in your estimation have any other implications such as the obligation of the state, let's say, to be paying its bonds? Or could it use the same argument that under the police powers we're going to have to renege on our bond obligations?
That was the end of my argument. I pointed out in argument quite specifically that the state in its brief complained that it could have a problem with bad credit, with the bonds falling if it can't deal with this situation. In its oral argument, the state said that that's an emergency situation it needs to deal with. For those who saw the end of my argument, they heard me say specifically that we have approximately a $50 billion market in Illinois bonds. If this court comes out with an opinion that says that the state can renege on those contracts by claiming police power, what is going to happen to that bond market? What's going to happen when everybody who holds those bonds suddenly realizes that the state may not pay on them? What does the value of those bonds become? I think that's a major danger for the state's credit, and I speak in terms of the bonds. But what about the construction company that says, I'm going to build something for the state, and suddenly says, you know, the state may not want to pay me, so I want all my money up front?